Edu Boahen ne wife any omo medi Ghana skenina mo ena chese Attorney General hwehwemo ebeye mretie bi ni ye hu sa Attorney General tata Edu Boahen any Office of the Special Prosecutor OSP ne nyagro ye se Edu Boahen afa Ghana sika 49 million Ghana cedis. 49 million Ghana cedis. O create company ekra edin to said National Signals Bureau the onoya boss no aban mu de no o create ni private one sikane na na machire omo chesensem ni say basa Ghana ska wana money Ghana money African money oga the chop am nyafo update aba na update aba ne de esewani ankasa ntimebo videos ama wahu say yes me ma wo evidence na say at omo court no omo ka say judge ni e bias so say nti omo mpe judge ni nti omo apply for a year prohibition eni nyama bi e wo Supreme Court na omo ko apply no Supreme Court no Supreme Court enfiom Supreme Court enfiom Edu Boahen the Keka is going south, is going in the wrong direction. Charlie, me say Ghana pa munshi esika. Me sound song who say if only what the OSP and the Attorney General what they are doing is the right thing, I don't have a problem with that. This is FMS Trends, and here we give you the latest updates on issues and enjoy the videos that we post on our pages. Untiasia, Kowechi, OSP, any Edu Boahen just omuni no mu videos so wa macheche mun kakran FMS Trends. Don't forget to like, comment, and subscribe. Ehu hiya nkasa. O comment ne, o subscription ehu hiya. Eno wo like just bibia obeye we page so bi ehu hiya. Ehu hia muhu antintin ene ye wa hase muhu nti ene ye wa hanum se na ye nto aso iti baby aye dru no eye lawyer for Edu Boahen ono ne ko file for sade no court but before that no me bebo video bi amamatie video ne ya Attorney General o kasa o church ensem or church in the sense that sika or maybe properties or ma acquire. Hey Ghana ya bre papa sika your video.
From what I'm going to tell you, the massive wealth that he has accumulated from 2018 shows that it is possible for him to have bought citizenship in some of the countries or jurisdictions where you can actually, as an investor, buy citizenship. And also, his wife holds a British passport, which we have in our possession. Now, as I said, he is the immediate past Director General of the National Signals Bureau. He left office sometime in February 2025. NSB, or the National Signals Bureau, is a successor organization to the now defunct Bureau of National Communications. Prior to the enactment of the NSB Act, that is the National Signals Bureaus Act 2020, which transformed the BNC into the NSB, Mr. Edu Boahen served as Deputy Director of the BNC and subsequently is Director from 2017. In other words, he has been in the management and control of Ghana's signal infrastructure since 2017.
Enti baby aye drum se maka kire mo say information dey ba solid ones nkoa ena me de bremo na baby aye drum no eye lawyer for former NSB boss lawyer Atachia any omo kan woni na they staged a walkout in court because omo say judge ni a bias and sembi nkoyie to the extent that omo koyie ko office yoko invite omo free yoko ani e chi omo share car mu ne de omo ba court ye de omo ba court omo ju Attorney General hodada mako akwa print Edu Boahen a bank statement no eye be 100 pages no mo ba ye 10 just mo yi be 90 pages e frame into lawyer ne se on tiase o gidi se judge na ought no masem so the high court judge who is in charge of Edu Boahen's case, Justice Eugene Nyandu. Justice Eugene Nyandu. According to Atachia, lawyer Atachia, or say, or shema judge near bias on boa case into a file for prohibition, war Supreme Court. Or mon person known a bet was so di Edu Boahen as a nibio, or mother coy, or mother coy. Then so now update time, baby, someone who beginning, no baby, I'm starting feeling, I'm fine. You're going video, no?
Well, since 9 o'clock, as scheduled by the judge, we didn't see the face of the attorney general. Other cases were being adjourned. We were waiting until all the cases were clear, giving an impression that, look, this case is what matters to the judge the most. Now, yesterday, I filed a motion for prohibition in the Supreme Court, saying that we are not comfortable that this judge will give us justice. I brought it to the attention of the judge. I also raised an issue that we should adjourn the case and abide the outcome of the application to the Supreme Court. The case is just next week in the Supreme Court. The judge is saying no, he won't grant us the adjournment, and that he is ready to continue the case. As to why the judge is in an ambulance mood to continue the case and cannot wait for the Supreme Court for 1 week. He leaves marriage to be designed. And I'm caught between the rock and the hard place. How? The ambivalence that you want to disqualify a judge from hearing the case and you sitting to continue the case. I cannot answer in the Supreme Court, so I need to leave the chamber. And then, I leave him to do what he wants to do best. That's why I've left the court.
Are your client not going to be? Your client is still.
Well, my client is there. I know he can't do any legal work for himself, but they should be glad that the lawyers are saying that they can't continue with the case. They could have also gone out of the court, but they are accused persons because they agree with me. But because they are accused persons, they can't get out of the court. That's why they are there. Because they are accused, but not that they endorse what the judge did.
If you go to the Supreme Court, we are not preempting, and the Supreme Court sends you back to the High Court, how will your approach be?
Well, let's leave it to the Supreme Court. I don't want to play clairvoyance, but I think we have a good case for the Supreme Court to consider. That's what we are doing. We don't know what the Supreme Court will do, and you don't want to play lottery with this very sensitive case.
But Counsel, regarding the decision by the judge, he cited two conflicting authorities and decisions by the Supreme Court, for which reason he used his discretion to refuse your application. How does that come to you, seeing that you chose to walk out when really he used discretion?
What discretion is on this matter, in which there is an old authority, the Supreme Court has departed from the authority. And the Supreme Court in 2020 is asserting that when there is a pending application for prohibition and the lawyer tells the judge looking after the affairs of the case that, look, adjourn the case and let's wait for the Supreme Court to determine the matter. And if the judge should not do that, it implies that the judge is biased. If you see the Supreme Court decision and don't want to respect it, I can't force him to obey the Supreme Court, which is at the summit of the justice delivery system. I think we'll have a day in the Supreme Court.
Okay.
Kwabena Boahen and his lawyers are concerned about the demeanor of the judge at the High Court. They are alleging that the judge is not. They are alleging that the judge's role is not being played the way they expect it to be played. So Kwabena Boahen here and his lawyers have brought legal action against the judge. And tomorrow the Supreme Court will be hearing the application, inviting the courts to endorse their suggestion that the judge be removed and the new judge placed there. It's part of legal procedure that you can ask for the judge to be removed and another judge placed there if you feel that the judge has exhibited bias, unhealthy bias against you one way or the other. But you have to cite cogent reasons why you think the judge has done so. And in the affidavit attached to the writ, Kwabena Boahen cites those things. Let's look at them right here at the beginning. This is this is the Attorney General, the Dr. Dominic Ayini, the Learned Attaching Counsel for Kwabena Boahen, and this Deputy Attorney General Sremsai all three of them very critical to the matter. Now, Edu Boahen seeks an order of prohibition against the High Court judge in the matter of the Republic versus Kwabena Edu Boahen. That's the way they say it in law. He's looking for an order to prohibit the judge from continuously sitting on his matter as a High Court, as a trial judge. They want the Lord Chief Justice to change the judge. If the panel of Supreme Court tomorrow were to agree with Atacha, then the Lord Chief Justice will have a duty to remove the judge and place another person there so that the trial can continue. So what are the reasons that Kwabena Edu Boahen is given or is asking for the courts to agree with him? Now, these are the summary of the reasons, and we'll go into the details in a minute. Reason number one, Kwabena Edu Boahen and his lawyer said that the High Court judge has shown bias by holding court sittings with the prosecution present while Edu Boahen was yet to be brought into the courtroom. They are alleging that. Two, they say the High Court judge has shown bias by insisting that he continues with the matter while there is a pending appeal against his decision. We'll explain this in some detail in the next page. And then number three, he says the High Court judge has shown bias by preventing Edu Boahen from having access to important evidence needed for his defense. So the High Court, so they are saying that the High Court judge constituted court at 4:30 p.m. They were not aware. They were bundled into a car and sent to the court. By the time they got to the court, they saw the Deputy Attorney General and the Attorney General suggesting that these important prosecutors were aware and that they, the other side, were not aware. They believe that is offensive to the Criminal Procedure Act 30, I believe. The second one, they are saying that the High Court judge has shown bias by insisting that he continues. So normally when they bring an application before a High Court judge, he can have a decision on it. He makes his decision. If the parties don't like it, they go to the Court of Appeal or the Supreme Court for a review of that decision. Now, they're saying that whenever that happens, typically the judge must stay the proceedings and wait for the court, especially if they are saying that without this matter, we can't move on to defend ourselves. The judge says, I don't mind, go ahead and defend yourself. But if they sue, as they say, they sue upstairs, and they're asking for a judicial review on the matter, typically the judge should hold. But they say that the judge says here, he says he's not willing to hold. Okay, so let's get into the details of the grounds. Ground one, which is ground one, is the High Court judge has shown bias by holding court sittings at an odd time. This is the case. On 30th April 2025, Angela J. Boahen, Charles Edu Boahen, and Mildred Donko and their lawyers were invited to meet officials of the Economic and Organized Crime EOCO. But after a 2-hour wait, they were unexpectedly detained by armed EOCO personnel and taken to the High Court, despite protests from their lawyers, Samuel Atacha and Kwame Oseasare and Peter Osea Samoa. They were ushered into General Jurisdiction Court 10, that's a courtroom, where the Attorney General and his deputy were already present. The lawyers, caught off guard and not formally dressed for court, were served with a charge sheet and prosecution facts that had been filed earlier the same day. In violation of legal procedure requiring prior notice, it will mean that the charges were filed and the court made aware and made to sit the exact same day. The presiding judge, His Lordship John Eugene Nyante Nyadu, proceeded with the arraignment despite objections, and the group exited the courtroom at about 4 p.m., at about 6 p.m. Now, Kwabena Edu Boahen is saying that this is untoward, this is not part of the legal procedure. You don't surprise an accused person by asking him to come to an investigative agency, EOCO. He's at EOCO for 2 hours. He finishes, hey, come and sit in this car. He sits in the car, they are put in the car, and they are sent to a courtroom. Then the Attorney General is already there. The judge is there. It's past 4 o'clock, normal time for the court to close, but this judge was sitting, waiting for them, and then they served them with a charge sheet, etc., etc. So that's ground one. Ground two, that the lawyers of Edu Boahen filed an application praying the court for an order directed at the Attorney General to disclose all the pages of evidence required. This included some pages of a bank statement produced by the Attorney General, as well as evidence of certain procedures that are used by the national security architecture. The application was because some of the pages of the documents provided by the Attorney General as evidence against Edu Boahen had been deleted and could contain important evidence to prove his innocence. Further, the court's order for national security to disclose its procedures would have aided the defense, show the court that what Edu Boahen did was standard practice in national security architecture and was not theft. So on this one, the Attorney General brought a document to the court to prosecute Edu Boahen. It's a bank statement from one of the banks. Now, the bank statement has about 100 pages, but the observation was that about 90 pages were taken out, and the court didn't see it. It wasn't in it. So the Edu Boahen's lawyer says, but what's going on? You have a bank statement that has Edu Boahen's transactions. It's 100 pages. Put all there. We will show you what you are looking for. We'll show you how it works. But you have taken this substantial amount out and you are submitting to the court a few documents. I mean, if this is true, it's quite bizarre. If it's true, it's very, very bizarre. You are a defense person. They bring your bank statement and they've taken some out. How are you going to deal with that? Why should the prosecution be allowed to do that in a democracy and in a normal court practice? So they are arguing against that. That's not correct. I mean, if this is true, this is very serious. Also, they say that the things that you are accusing Kwabena Boahen for is a standard procedure of the national security architecture. Bring the national security people in. Let us ask them whether this is not their procedure. Whether in 1993 they didn't do the same thing. Whether in 2016 they didn't do the same thing. Whether in 2011 they didn't do the same thing. And then the prosecution says, no, I'm not going to do that. And they make an application to the judge. The judge says, I'm not going to allow you to do that. It is as if you want to tie his hands behind him and shoot at him. You don't want him to be able to defend himself because the material that he's going to use to defend himself is within the bosom of the prosecution. Sometimes they call it discovery in legal practice. But Edu Boahen is complaining about this as a second ground. The third ground, Edu Boahen says that, okay, so on the second ground where they are not allowing him to defend himself, he's relying on a recent case of Republic versus Bafuboni in which the current acting Chief Justice ruled as part of the matters. And it was said that they should allow the prosecution should give to the defense anything that the defense needs that will be needed for the evidence in aid of the defense case. Prosecution and the court should allow the defense to get everything that the defense needs, even if they have to get it from the prosecution, which will allow and aid the defense of his case. So Kwabena Boahen cites this as the reason why he thinks that the judge should comply and allow them to get the full document of the bank statement and also the national security procedures. They should bring them to the court. Now, on the third ground, he says that upon refusal by the court's order, the Attorney General to provide full disclosure, Edu Boahen's lawyers appealed the decision by the judge, insist on continuing. Edu Boahen appealed the decision by the judge. I appealed the decision, but the judge insists on continuing the trial despite a pending appeal before the Court of Appeal. This is all on the backdrop of the judge acceding to request to the Attorney General to deal with certain matters earlier than has been fixed for determination in the court. So this is very, very, very concerning. Here, Edu Boahen's lawyers are saying that based on the fact that the judge says he will not allow them to get the full bank statement, they filed an appeal to the Court of Appeal, told the Court of Appeal that, look at this, we need this to defend ourselves, but the High Court judge says that we are not entitled to it. Now, whilst the Court of Appeal is preparing to hear the matter and give a decision one way or the other, the High Court is continuing with the trial. That whether you have it or not, I'm moving on. I'm going on with the trial. He may go on the trial and get to the end of the trial whilst the Court of Appeal is yet to bring the decision down. So they are saying that, no, let's go to the Supreme Court and say that based on all of these demeanor findings, we believe that this judge should be prohibited from continuing to hear the matter. The Supreme Court hears the matter tomorrow morning. Good luck to all parties. But we hope that the democracy is built as a democracy. It's not built as a democracy of an oligarchy, or it's not built as a democracy of some feudal state. Democracy is democracy. Transparency is important. The judicial strength is important. People must have the right to defend themselves. All of those ethos guaranteed by the 1992 Constitution must be very important. If a person is guilty, he's guilty. But let's not be hearing these things from the court, and let's hope that these things are not true. The Supreme Court will have their decision to make tomorrow.
Now, Mohu. Someone baby, I made a mood drew Timer or Marco Supreme Court and a Supreme Court there. And they are in a mobile filing wahano. Prohibition, din. Mufama some cocrana, judge and uncle twas no dia some neon coyanim. Mukasa grony yedi wa Ghana sika. 49 million Ghana cedis. Mato top properties. Just say a biafa accounts be more Google baby. Yeah, can't some massa be janum say judge near bias intine. Yen Supreme Court. Yen change judge na see my man to a case. So mufama some call into prohibition no more file na or more apply Supreme Court no and Supreme Court abasem na to latest update o into no lawyer attachia any other lawyers or more form a legal representative for Edu Boahen and the wife no more involved in this brouhaha no omo pay free Supreme Court no omo hia omo yanka se anuanu hia omo ebisa no so asem na Supreme Court atoagu no ono lawyer attachia de ehano but or ashenedie, but he's not discouraged. That is why I say obekon koden amedu Boahen. Ye video no ati.
Let's go.
Yes.
Your request to have the judge prohibited obviously has been turned down by the Supreme Court. Your immediate reaction?
Well, I'm disappointed but not discouraged. We'll see how the case will travel.
How does it feel going back to the same court that you...
It doesn't move me at all. The only persuasion a judge will have is the law. I'm not going to have a banter with him. I'm not going to fight him over anything. I'm just going to project the law. It doesn't move me at all.
Are you looking at appealing against the decision?
Yeah, this is a 5-0, so that is a tall order. You may review.
Yeah.
So that's a tall order. So we'll soldier on.
All right, thank you.
This is FMS Strengths. I hope you enjoy the video and manka someone dada updates biaba ya de bremo. Don't forget to like, comment and subscribe and share the link to your friends as well. Normal sombe subscribe. Somebody can catch you. A be a video we want share down tiase gidigidia. Koye page nim FMS Strengths. Ya cheche mu mako. Edu Boahen ne yire etese issue ni na egu hono ma obetiase simple cra. All the videos that we played, we don't own rights to them. No copyright infringement intended. Thank you.